Your recross can only be for new material or material that needs clarifying. And that's a pretty narrow list, and I wanted to make sure you had a minute before the jury came out to get those questions straight in your head. Does that make sense?
Yes, sir.
Okay. Are there any questions I can answer for you about that? And again, just pull that mic too. I mean, as you can see, I keep it kind of right up here next to me.
I can't get anything right now, but what you said, you don't want to go over about the same thing that we go over yesterday, so
That's correct.
I just finished at that.
Okay. So that means that what's about to happen is Larrabee's about to come back up here to the stand, and we're going to bring the jury out, and then I'm going to say, you may begin your cross-examination. And then you're going to start asking questions, or you're going to say you don't have any questions. Yesterday you said you did. And then we're going to do those questions, and then I believe you said that's your last witness? Or you have?
Yes, it is our last witness. I did have one other point that I wanted to clarify with the court. I went and pulled the other body cam.
Yes, oh yes.
And it is of her booking, but it is Officer Larrabee's body cam. It's about 15 minutes.
Okay. Was there anything in there as an officer of the court after you reviewed it that was relevant to this question on the table today for this trial?
No, Your Honor. It starts when the car pulls up to the jail.
Okay.
And then it shows parts of her booking. It's Officer Larrabee in the jail talking to other officers, but you can sometimes see her being booked in the background.
Okay. And you're wanting that, Ms. Douglas, to be part of this record?
Yeah, if they're going to show everything, like when all the police get around with the gun with the and the hip, and nurse is there, and they're giving me some water with something in it. I don't know what in it, so I didn't take it. So if they could show all those.
Okay, so here's what we're going to do.
If it's not that.
The rule of completeness was satisfied when the video you put into evidence was played in full. So her request that the rule of completeness include the second video is overruled. However, what we'll do is, I'm going to think about this a little bit, but I'm not hearing anything. What we can do is just have you mark it as, let's just do this. Just mark it as states, or where it's officially on our records, it's just going to be states 3. I think that's where we're at. But we're not going to tender it a minute, but at the same time, it'll just be part of the record. And that way, if there's ever an issue, it'll be part of the review. So, but again, I haven't heard anything, and she has not given me any argument that has persuaded me that this video of her being booked would be assisting in any way. So again, if somebody has a very strong feeling otherwise, let me know. But I haven't heard anything that make this video relevant. But so if you don't mind making that states 3, I can make it courts 1 if you want to object. So.
I have no objection.
Okay. Well, it's not tendered for the jury. It's just going to be part of the record in case there's an appeal. Okay. Anything else, Ms. Douglas?
No, sir.
Okay. Are you ready for your questions?
Yes, sir.
Okay. Ms. Douglas, when the state rests, I'm very likely going to turn to you and ask you if you wish to testify. You had indicated earlier that you did wish to testify.
Yes, sir.
That's another reason I went ahead and broke last night, because I wanted us to get a good night's sleep to make certain that this morning at 9:05, you were absolutely positively ready to make a final decision as to whether or not you wanted to testify or not. You understand you have the right to remain silent.
Yes, sir.
You understand that if you choose to remain silent, I will not allow that silence to be held against you by anyone.
Yes, sir.
If you choose to testify, you'll be cross-examined by Ms. Tony, and you will be required to answer all of her appropriate questions. Do you understand that?
Yes, sir.
Do you wish to remain silent, or do you wish to testify, or do you have additional questions you would like me to answer?
No, sir.
Okay, so do you wish to remain silent or testify?
I'll testify.
You will testify. Okay. All right. Well, then what's going to happen is, instead of the traditional break where I send the jury out between the state resting and her starting, we're just going to go ahead and pivot straight over to that. And after her testimony and your cross, we'll break at that point. So, because I've almost got the jury charges finished, but I don't quite have them where I want to release them yet. So, all right. Any other housekeeping, Ms. Tony?
No, Your Honor.
Okay. Any other questions, Ms. Douglas?
No, sir.
All right. If you will ask the jury if they're ready, and obviously if they want to bring out their coffee or whatnot and their notepads, they're welcome to do so.
Just, that's what I want to ask.
Okay.
That when you come on the scene where you saw me, I was right there to turn an Aman, waiting for the passing car to go by.
Ma'am, I'm not sure what the question is.
My question is, you said that I didn't yell, I turned in front of the gentleman. So I'm just asking you, when you came on the scene, where did you saw my car?
Your car was parked facing westbound on West Poplar Street, right at the intersection of Hammond Drive.
Yeah, that's the car, that's where I'm going to make the left. So I couldn't make the left until the passing car passed. And I was parking right there to make the left when I hear bombing my car back.
I'm sorry, ma'am, can you repeat the question?
That's where I was standing right there, I'm on to make the left. And when I parked there waiting to make the left, that's when I hear the bang in my car back. So I was just speechless because I was saying what happened, what's wrong. So, but the question I want to ask you, when you came, you saw me park right there at Aman, because that's where I was going to make the left. Because it's a short left from off Taylor to Popular Street. And that's why I passed it the first time, because it's just I didn't see. So when I passed it, I see the name. So I go around, right round and come back. And then right there where I supposed to make the A like start right there on Taylor. When I was there first, there was 2 cars in front of me. And each car got to wait until the vehicle then pass before they could make their right. So why would I not know to wait there to make my right? There wasn't anything coming when I made my right turn right there on Popular Street. Nothing was coming. So I don't know where he was coming from, if he was coming from Taylor or Popular Street. I don't know, I didn't see him. When I made my right there was nothing coming. The only traffic coming is from the other side.
All right, interpret that as a question and answer it to the best of your abilities.
Ma'am, I don't understand your question. I apologize.
If you break it down into smaller pieces, you may be able to successfully ask questions that can be answered. So if you'll just ask smaller questions, you can probably get an answer. Try that.
Okay, when you come on the scene and you saw me, where was I stopped at?
As I previously stated, you were facing westbound on West Poplar Street, ma'am.
When you come and see me and you ask me what happened, and I told you, where was I parked at? It was right there, and I'm on to make my left turn.
You were.
Yeah, I'm on Popular Street, so I
You're-
got to make the right,
Okay,
the left
he was
turn.
answering your question,
Oh.
and then you cut him off. So
Okay, sorry.
Like when I got on scene, you were parked on West Poplar Street facing westbound, right at the intersection of Hammond Drive.
Yeah, that's where I was going to turn, right there on Ammon Drive.
I've never disputed your intent to turn on the Hammond Drive, ma'am.
Okay. And then you told me, you said, when you put the handcuff on me, it was you put the handcuff anyway as a other officer. When the sergeant come and he asks you why you put the handcuff on me, yesterday I asked you, you said nobody didn't tell you to take the handcuff off me. So, but on the video, it shows you were saying that you tried to take the handcuff off me and I would not let you. But yesterday you said No one told you, and you never tried to take it off. You didn't recall, you didn't remember.
No, ma'am, at the time you asked me, no, I did not recall the exact conversation I had on the scene. It was approximately a year and a half ago.
So, if I did also wrong what you said, when you give me the card and say to get the statement in 3 days, you didn't take notice or you didn't ask any question to the other gentleman to see who wrong or who not wrong, because I tell you on the scene what happened, and I tell you where I was going and the turn that I was going to make. So I just don't understand. You didn't give me a ticket at first because I told you what happened, and you was on the scene to see what happened. So you only questioned me, you didn't question the second person. And you didn't, I'm not going to say you didn't do your work right. I'm not going to say that, but you wasn't paying much attention on what's taking place or what did I say or what happened, where my car was when it came on the scene.
Ma'am, I don't understand what question you're asking.
I'm just asking you. You said when you go and ask the other tell the other gentleman you're going to give him a ticket, and he said to you, "Why are you giving me a ticket?" She pulled out in front of me. What I'm saying, why he didn't tell you that from the first?
Ma'am, I can't answer for another individual why he did or did not tell me something prior to the moment you're speaking of. At the time I stated that I was going to write him a ticket, I had not, an error on my part, I had not completed my investigation. And I did my best to correct that error.
Yeah, you did your best to correct the error, but you know in your heart that I was not wrong, but you gave me the wrong. And you know in your heart that when you came, you see me park right there. That's where I get it in my back.
All right, interpret that as a question as to whether or not you made a mistake in issuing the citation.
In my initial evaluation of the wreck, yes, ma'am, I did make an error. Once I completed my investigation, I feel as though I got it 100% correct at the end.
I just don't feel like you did the investigation right.
That's a statement.
Oh,
You can turn that into a question if you would like, but you are not allowed to make statements. And I will remind you that the questions, ladies and gentlemen of the jury, are not evidence. The questions are simply a ways to elicit evidence from the witnesses.
oh, it's just over. I'm just saying that I was just doing my job that day, and I followed the right procedure by stop and hail. I always do that.
Okay. You're going to interpret that as a question and you're going to answer as to the best of your abilities.
So
Not the part about always. That's irrelevant.
Ma'am, I don't understand what question you're asking. I'm sorry.
I'm just saying that that day I do the right thing. I hail, I turn right, and I'm just going to make a left, and Amman, and that's where I stop to make my left. And that's not where you see me parked at.
Ma'am, I don't understand what question you're asking me.
Okay. That's all. That's all.
You may step down.
Thank you, sir.
Ms. Tony, you may call your next witness.
The state has no more witnesses, Your Honor.
Okay. Ms. Douglas, does the state rest?
The state rests.
All right. So ladies and gentlemen of the jury, the state has rested, which means they've now provided you with all of the evidence they will be providing you in their case in chief. There's a rebuttal section, but we'll come back to that in a minute. The defendant now has the opportunity, I stress the word opportunity, but certainly not an obligation to testify. The reason why we came in this morning and started was because we're normally required to take a break at this time and do several things outside of your presence. We went ahead and did a little bit of that last night and a little bit more this morning while y'all were back in the back, or not here last night and back in the back this morning. And so we're going to pivot straight into the defense's case. All right, so Ms. Douglas, as we've just discussed earlier, you have the right to testify at this moment, but certainly not an obligation. And if you choose to remain silent, I will instruct the jury not to hold that against you. Do you wish to testify or do you wish to remain silent?
So, if I'm going to testify, I'm going to talk the same what I said yesterday, right?
Well, what you said yesterday was opening statements. It was not evidence.
Okay.
So do you wish to testify or do you wish to remain silent?
I'm just going to remain silent. I'm just tired.
Okay. Okay. So, all right. So that moves us, actually, that moves us into a section where I do have to have you step out. So, so members of the jury, grab your coffee cups, grab your notepads. Y'all head on back to the back. This next part's going to be a couple minutes, so y'all settle in. When we come back out, we'll be in the home stretch. Okay, jury's out. Y'all can grab a seat. All right, well, the defendant, I think she and I have gone over that question about 4 times so far, getting ready for this moment. And Ms. Douglas has elected to remain silent and not testify. Therefore, I will be instructing the jury that they are not to hold the defendant's silence against her. With that said, that means that as there is no defense evidence being presented, there's no rebuttal, which means we need to do the charge conference and get organized for closing. Let's do this. I'm going to walk through a little bit of closing with Ms. Douglas, and then while y'all kind of get your notes straight and organized for your closing, I'm going to finish polishing up my charges, and then we'll review those. Does that work for you, Ms. Tony?
Yes, Your Honor.
Do you have any housekeeping we need to discuss before we go off record and go to our own little corners here?
No, Your Honor.
Ms. Douglas, we're about to do what's called closing argument.
Yes,
And
sir.
I need to remind you that closing argument is where you sum up the evidence to the jury. And remember, evidence is the information that was testified to by the witnesses and the document and the video that were placed into evidence. Now, I ordered the state to put the 3rd video in, but you're not to reference that 3rd video at all. That is simply for record purposes only. Do you understand that if you mention the 3rd video or the 2nd video, the 3rd exhibit, I will stop you and I will admonish you in front of the jury? Do you understand that?
Yes, sir.
All right. So do not in any way whatsoever reference that one. I just put it in there as a courtesy to you, and I almost didn't even include it at all. So, in closing, you can sum up what the evidence was from the witnesses, including the exhibits, and why you think that evidence should show that you are not guilty. That's your summary. And then obviously Ms. Tony will be doing the same in the opposite direction. I am finishing up what are called the jury charges. Those are the written law that the jurors will use in making their decision. I almost have it complete. I'm going to finish it up here in the next couple minutes, print copies, and let y'all take a look at it. But while I'm doing that, what I want you to do is think about what you're going to say in your closing. Ms. Tony, I was kind of thinking procedurally of doing my charge since you have my pattern charges, I was kind of thinking of doing my charge, and you'll need to talk to Mr. Shepherd about this before you answer, of doing my charge before y'all do your closings, so that you can say, you heard the judge say, and you'll have my, you can say, well, that was on page 9. I don't really want you to remember that part. So y'all think about that. Obviously, if you don't want me to go before that. And then the last little part I would do at the end would just be the whole, you may now go out into the jury room, select your foreperson, that kind of thing at the very end. Are you going to want to go first, last, both?
Last year.
Last, okay. So that means, Ms. Douglas, when closing starts, you will go first and Ms. Tony will go last. And that's the way Georgia works. She gets to make that decision. So, okay, while you're getting ready for your closing, talk to Mr. Shepherd, see if y'all are okay with me doing my charge beforehand. Or if y'all want me to do it after, you have the right to demand that it be done after. So, and you're not going to hurt my feelings. I just was thinking that might flow better. So, okay, that's it. It's 9:30. We're off record for a few minutes. You be thinking about your closing, Ms. Douglas. You work same thing, and I'm going to finish up the charges. We're off record, everybody.
trial. 'Cause I
Are you
know-
indicating that you have not received a fair trial?
No, I
You
mean,
said you wish you had received a fair trial.
I mean like what the officer's saying, because he know that when he came, he see me right there to make a
Okay.
left turn.
Well, most trials, Ms. Douglas, involve one side saying something happened and the other side alleging that something else happened or something else was said. That's the whole point of the trial process. If we all agreed on everything, there would be no need for a trial. And so this is the trial. And those 6 jurors will decide what the truth is. You say the truth is not what the officers are testifying to. Larrabee testified that that was his truth and that was what happened. And the jurors got to see the video. So they will make their own decision. And I don't know, I'm prickling a little bit at what you said, is that you wish you had a fair trial in the past tense. And I just feel like I am bending over backwards here with the way you have chosen to do this trial to help you move to the end of this. So I just want you to know I'm really taking a deep breath in my soul right now because I feel like you've gotten a fair trial, no matter what the jury does next. I feel very confident that the Spalding County State Court has served you well and has let you try your case.
Yes, sir. And when I say that, it's just killing me to know that I'm not perfect, but I do the right thing. When I'm driving, I do the right thing. Can I say something? When I was getting my license, it was,
Hold on. Any objections to my charges?
No, Your
I'm
Honor.
going to hit print because they take a couple minutes. Hold up. Go ahead, man.
yeah, when I was getting my license, I was so scared, like, because it was an officer, it was, it's okay. It was a white guy, and he's the one that gave me my driving lesson. And I know when I take that Pearl Park, he said I go too much back, and he said, "You're scared. Why you scared?" And he said, "You scared of me?" And I said, "No, sir." But I was really scared, think I was gonna get it. And he said, "Go on the street. Let me see what you can do." And when I go on the street, I do everything I know I'm supposed to do. And when I finish, he said, "I'm so proud of you, because I'm watching you to every stop you make, every aisle. You stop and you look and you pay attention to." And that's what I did. From that, he said, "You're going to be a good driver and keep it up." And that's what I do. I always stop, look, make sure everything is right before I do. And I know I didn't turn in that gentleman. I know I stop on Yale and I turn right and pop it off Taylor to Popular Street. And I'm going to make a short left right there on Ammon. And that's why I passed it from the first time, because I didn't see it. So I try when I'm driving, I always try my best to pay attention and do the right thing. Versus when I have my grandkids in there, I always do that. So I didn't go out in front of the gentleman. And when the officer came, he see me right there at Ammon, and I give him my statement. So, that's why it hurt so much. I was crying.
Yes, ma'am.
I know I said on the scene that, because I know there's some good policemen out there. I know there's a lot, because I know there's a lot of good policemen. But I just feel like the officer just didn't do me right,
Well, Miss
you
Douglas,
know.
for 25 years of my life, I have been in some capacity in the criminal justice system in this area, mostly in this building. First as a prosecutor, so I was upstairs as an assistant DA, and then as a defense attorney, where I stood with people who were charged with crimes, and now as a judge. And for those 25 years, Ms. Douglas, I am keenly aware of the fact that I am on the very front lines of racial issues and race divide and race inclusion and everything in the middle in this community. And I take that responsibility and have always taken that responsibility very seriously. Have I done it right every time? No, I've not. But you will see in those jury charges there that one of the things I give in every single charge is a charge to the jury to remind them to take a deep breath and look in their soul and make certain, because I heard the allegations on the video and you've said them a couple of times in this courtroom, that you are concerned about the color of your skin and your heritage factoring into the decision of whether or not you are guilty. And I am going to very specifically tell the jury that they are absolutely not to consider that. And obviously, I'm live feeding this, and my kids are going to watch this, and I don't want them to ever look at me and say, yeah, you treated that person differently because they had more pigment in their skin than you did. So I just want you to hear me say that I'm not saying those things don't exist. And I'm not saying that I've ever come up short, because we both know I have. There's only one perfect person. It wasn't me, and it wasn't you. But we're going to do everything we can to make sure you get a fair trial, and we're going to finish this trial this morning, okay? And I understand what you're saying to me, but there's no scenario where you finish that statement and I just dismiss your case or we close it out. The jury is going to make this decision on your case. All right,
Yes, sir.
I'm going to step off the bench. I'm going to grab your jury charges. Are you ready for your closing?
Yes, Your Honor.
Ms. Douglas, are you ready for your closing?
Yes, sir.
Okay,
Yes, Your Honor.
let me go get y'all's jury charges and then we'll be done. If you'll tell the jury that we'll be ready in about 5 minutes. Anybody needs to use the restroom, this is your chance. Okay, I think we're ready. All right, Ms. Tony, coming to you, do you have any objection to me doing the jury charges first?
No, Your Honor.
Okay, again, I knew that was a little bit odd, but I thought that it would, I honestly just thought it would flow better. So, and because you spend most of your closing saying, the judge is going to say. And I thought, if I already said it, then you can say, you heard the judge say, which I feel is a much more appropriate way, and you can point to where I said it. And I can listen to your stuff better instead of preparing for my own. Ms. Douglas, is that okay with you? That I know you don't normally do a lot of court procedure, but normally y'all do your closing and then I read this, but I'm going to read this first when they come out. Is that okay with you?
Yes, sir.
Okay, I just want to say out loud that I am doing something a little odd because I want to try it, because this Fulton County State Court judge does it this way and says it's much, much better. So.
Have you been doing that in civil?
Yes. So that's the thing we've been doing. I've been doing it civil my whole career, but I've never had the courage to ask y'all to let me do it over here. And the civil attorneys love it.
That's how I used to do it in civil.
Yeah, they've universally said they love it because they get to say you heard the judge say instead of,
I like it better.
so, anyway. Okay, ready, Ms. Tony?
Yes, Your Honor.
Ready, Ms. Douglas?
Yes, sir.
All right, if the jury is ready, they may come out. Okay, so, members of the jury, we have now finished all the evidence. We've had what's called our charge conference, which is a conversation we're required to take outside of your presence, and we finished that. So we're now almost at the end of this trial. I told you earlier yesterday that this is not going to be a long trial, but it's also a very important trial, and I think you all are well aware how important this trial is for all the parties here, and as you'll be able to see how many years they've worked to bring it to you. So what the next couple of steps are is as follows. So what's going to happen next, and you can see that I've put up on the wall there, the charge to the jury. So this is the part that y'all have been waiting for this entire trial. This is the part where I dramatically read to you the law in this case. It is just as exciting. No, let me put it this way. It is just as important as it is boring, but it is that important. So what's going to happen is I'm going to read it to you. While I'm reading it to you, it's going to be up on the wall, and then you will have it with you back in the jury room when you make your final decision on your case. So just be aware that you will have that. When I have finished reading this, which it takes usually about 15 minutes to get through the whole thing, I will sit back, at which point the closing arguments will happen. Now, I'll remind you that evidence is one thing and one thing only. It is the witness, it's the testimony given under oath from the witnesses, and then, of course, through them, any documents and evidence put in, exhibits put in. So closing argument is not evidence. It is simply both sides' attempt to sum up what the evidence was and why you should find in their favor. And so you're going to hear me say that you're to find this decision only on the evidence. So the state has the right when we go to go first and last. And so you'll hear me ask Ms. Tony as soon as I finish whether she wants to go first or last or both. She'll elect at that time, and then we'll do the closing. And then as soon as we do closing, you'll have the case to make your decision. Okay, so without further ado, here are the jury charges that you are required to apply in making your decision in this case. And I'm going to be looking up here, but y'all can choose whichever monitor you want. All right, this is the charge to the jury. This is the state of Georgia versus Dolores Angela Douglas. This is the state court of Spalding County, accusation 23 TK 2844. And this accusation was originally filed with this court on June 23rd, 2023. You are considering the case of the state of Georgia versus Dolores Angela Douglas. The defendant in this case has been charged. I hit the wrong button. You know, technology. By accusation filed with the Solicitor General of Spalding County with count 1, failure to yield at an intersection. See accusation 23 TK 2844. And that document, when you're looking at it, will be in this second packet. Remember, this is the joining of the issue here, the plea of not guilty. This is your verdict form down here. And on page 2 reads the accusation. All right, the accusation reads, on behalf of the people of the state of Georgia, the undersigned as prosecuting attorney for the county and state aforesaid does hereby charge and accuse Dolores Angela Douglas with the offense of failure to yield at an intersection, that the said accused in the county and state aforesaid on or about the 11th day of May, 2022, did unlawfully, while operating a motor vehicle upon a public roadway, did fail to yield when entering or approaching an intersection, to wit, Hammond Drive and West Poplar Street, to another vehicle at the intersection as required by law, this being contrary to the laws of the state, the good order, peace, and dignity thereof. Patrick M. Shepard, Solicitor General, Spalding County State Court. I will remind you again that the accusation was originally filed in this court on June 23rd, 2023, and to that accusation, the defendant has entered a plea of not guilty. The accusation and the plea of not guilty form the issues which you have been selected, impaneled, and chosen to try. All right, presumption of innocence. So presumption of innocence is where a defendant is presumed to be innocent unless and until proven guilty. A defendant enters upon the trial of this case with a presumption of innocence in their favor. The presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. Proof beyond a reasonable doubt. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. Burden of proof. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. Reasonable doubt means just what it says. A reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After considering all facts and circumstances of the case, if your minds are wavering, unsettled, or unsatisfied, that is the doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your mind as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Evidence. Your oath requires that you decide this case based on the evidence. Evidence is how any fact that is put in the issue is established or disproved. Evidence includes all the testimony of the witnesses and any exhibits admitted during trial. Evidence does not include the accusation, the plea of not guilty, opening statements, closing arguments of the attorneys, nor question asked by attorneys. And in this specific case, I will add that the defendant is acting in the capacity of the attorney from the seat there. Direct and circumstantial evidence. Evidence may either be direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact. Internet's slow today. Circumstantial evidence is a proof of a set of facts and circumstances that tend to prove or disprove another fact by inference. There is no legal difference in the weight that you give either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct or circumstantial or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. Credibility of the witnesses. You, the jury, must determine the credibility of all the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their intelligence, their means and opportunity for knowing the facts about which they've testified to, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Witness impeached. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified, or another way to talk about impeachment is that the credibility of the witness may be attacked by disproving the facts to which the witness testified. Defendant's choice not to testify. The defendant in a criminal case may take the stand and testify and be examined or cross-examined like any other witness. If the defendant chooses to testify, you should evaluate such testimony as you would any other witness. However, I usually just read off the paper. I'm trying to be fancy this morning. Y'all give me just a little bit of patience here. All right. However, if a defendant does not have to present any evidence, nor is a defendant required to testify. If the defendant chooses not to testify, you shall not consider that choice in making your decision. Definition of a crime. The defendant is charged with a crime against the state, the laws of the state. A crime is a violation of the law of this state in which there's a joint operation of act and intent. Now, proof of offense and intent. Intent is an essential element of any crime, and it must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided that you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or acts or conduct, and in your discretion may be inferred when it is the natural and normal. Forget it. It keeps moving away. When the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean the intent to violate the law, but it simply means the intent to commit the act which is prohibited by law. There's no presumption of criminal intent. No defendant will be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, or other circumstances connected to the act for which the accused is being prosecuted. I just realized there's a missing paragraph in there that I'm going to add before it goes out about strict liability, and I'm just going to tell you what that is, and then when you get the charges, I'm going to add it in there. Intent in criminal cases is what's called a strict liability offense. The only, and I'm not commenting on whether the state has proven this or not. I'm simply telling you I forgot to add a piece of the law. And what I needed to add in there was intent in motor vehicle cases such as this simply means the intent to operate a motor vehicle. And I will include that language in there when you have it. Failure to yield at an intersection. After stopping, the driver shall yield the right of way to any vehicle approaching on another roadway so closely as to constitute an immediate hazard during a time when such driver is moving across or within the intersection or at the junction of roadways. Traffic citation signature requirements. A person who is issued a citation shall sign the citation to acknowledge receipt of the citation of her obligation to appear for trial. The officer shall advise the person that signing the citation is not an admission of guilt and that failure to sign will result in the person having to post a cash bond. If the person refuses to sign the citation, it shall constitute reasonable cause to believe that the person will not appear at trial, and the officer may bring the person before a judicial officer to post a bond as is otherwise provided by law. Venue. Members of the jury, the accusation alleges that each of the alleged offenses charged here in Spalding County, the location of the offense within Spalding County is an essential element of the offense and must be proven beyond a reasonable doubt by direct or circumstantial evidence or both. The date. Members of the jury, the law of our state sets a time limit upon which the state can start a prosecution. The defendant is on trial for a misdemeanor offense. Under Georgia law, the prosecution of this offense must begin within 2 years after the offense has been committed. In other words, the accusation was filed with this clerk on June 23rd, 2023. If you find the evidence that the accusation in this case was not filed with the clerk within 2 years after the offense was committed, it would be your duty to acquit the defendant. Deliberations and verdict. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented, and then you must apply the law that I give you in the charge to the facts as you find them to be. During your deliberations, you must shut off all electronic devices, do not communicate or receive information from anyone or provide anyone any information by any means about this case. You may not use electronic devices, including a tablet, cell, smartphone, computer, or any other device to access the internet, to communicate with anyone or get any information whatsoever about this case, nor to conduct any research until after I accepted your verdict. Sympathy. Your verdict should be a true verdict based upon your opinion of the evidence and the law given to you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, and sympathy to either party. You should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, gender, sexual preference, local or remote residence, economic status, for or against either party. Implicit biases. More specifically, do not decide this case based on implicit biases. Everyone, including me, has feelings, assumptions, perceptions, fears, and stereotypes. These are called implicit biases, and we may not be aware of these implicit biases. These hidden thoughts can impact what we see and hear, how we remember what we see and hear, and how we make important decisions. You are making very important decisions in this case. I strongly encourage you to evaluate the evidence carefully and resist jumping to conclusions based upon personal likes, dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. The law demands that you return a just verdict based solely on the evidence, your individual evaluation of that evidence, your reason, your common sense, and these instructions. Our system of justice is counting on you to render a fair decision based on the evidence, not biases. You are only concerned with guilt or innocence of the defendant. You are not to concern yourself with punishment. If after considering the testimony and evidence presented to you, together with the charge of the court, if you should find and believe beyond a reasonable doubt that the defendant did commit the offense charged in the specific count of the accusation, then you would be authorized to find the defendant guilty. And in that event, the form of your verdict would be, we, the jury, find the defendant guilty as to that specific count. And as I told you earlier with the verdict form, that would be actually on the right side of your verdict form at the bottom. If you do not believe that the defendant is guilty on that count, then, and if you have a reasonable doubt as to that defendant's guilt on that specific count, then it would be your duty to acquit the defendant as to that specific count, at which point the form of your verdict would be, we, the jury, find the defendant not guilty as to that, and you would come over here to your verdict form and you would circle not guilty, which is on the left of your verdict form. The accusation, again, has this verdict form for which you to place and indicate your verdict on the face of it. It says as to each individual count, but there's only one count on this verdict form. Whatever your verdict, it must be unanimous. That is agreed to by all of you. The verdict must be signed by one of your members as foreperson, dated, and returned to be published in open court. Please be certain that your verdict is completed in ink. I wouldn't put that on there if I didn't need to. One of your first duties in the jury room will be to select one of your number as foreperson. That was the person who will preside over your deliberations and who will sign the verdict to which all 6 of you have freely and voluntarily agreed. All right, you should start your deliberations with an open mind, consult each other's views. You must decide this case for yourself, but you should do so only after discussion and consideration with your fellow jurors. Do not hesitate to change an opinion if you are convinced it is wrong. However, you should never surrender an honest opinion to be congenial or to reach a verdict solely because of the opinion of others. By no ruling and comment which the court has made during the progress of this trial, has the court indicated any expressed opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. The court's only interest, my only interest, is that this trial be conducted fairly in accordance with the law. Once you've reached a verdict, you'll notify the bailiff. The bailiff will bring you out of the jury box. They'll identify your foreperson. They'll ask, and then I will ask your foreperson if you've reached a verdict. And if the answer is yes, I'll have your foreperson pass the verdict to the bailiff, who will pass it up to me. I will confirm that it is in proper form, and then I will read your verdict out in the courtroom. All right, I have a few more instructions, but those are going to come after closing arguments, but that is about 98% of the instructions I need to give you. So with that said, if you will please turn and give the parties your full attention for closing arguments. Ms. Tony, you, as having the burden, have the right to go first, last, or both. What is your preference?
We'd like to go last, Your Honor.
Okay, so Ms. Tony is going to go last. So the order of events will be Ms. Douglas will give you her closing argument, and then Ms. Tony will give you hers, and then I'll give you about one more page worth of instructions, and then you will have this case to decide. Ms. Douglas, the floor is yours to make your closing, and I'll remind you again, you're welcome to sit there and use the mic. You're welcome to use the lectern, whatever is most comfortable for you.
Good morning, jury. My name is Dolores Douglas, and on May 11th, about I think like 4:30 to 5, I was traveling on Taylor, going on to I'll make a right and turn and going to make a left and Ammon, but the incoming traffic I couldn't make that left. It's a little short turn from off Taylor to Ammon. So at first I passed that turn, so I go right around and come back. I stop as the first time, he yelled right away. There was nothing coming when I made my right, so I was supposed to make a short left. So I say park there, I stand there until the road clear to make that left. And after a little while, I hear bomb in my back, in my car back. First I hear like pop, pop, and then I hear a bomb in my back of my car. So I was sitting there, like I said, what happened? Because traffic was coming, so I couldn't turn. I make a call 911, and the officer came. He came out his car, he came to me and he said, what's wrong? So I said, sir, I was at Taylor, make a right, and forgot the street, and then I was supposed to make a left and Ammon. That's what I told him. So I said the traffic coming, so I couldn't make the left. So that's when I hear the bang I hear pop, pop, and then I hear the bang in my car back. So he said, you hurt? I said, my back just jerk up a little. So he said, okay, I'll be back. And he went to the other gentleman. Then he come back to me again. I think he said, if I'm okay. So I said, yeah, I'm okay. He said, we're going to drive to the Kroger. I'm not familiar around there, so he said, follow me. So I was following him, but I missed him because I think car was behind him. So he went and he turned in the Kroger. I didn't see where he went, so I go straight. Then after I turned around and came. So when I come to that parking lot, he asked me for my driver's license. I give it to him. I came out the car and go to the back of the trunk, and my bag was in there. Because I was running the lift, so I keep my bag in the back of the car. So I give it to him, and I think he called the ambulance, and they came and they said they want to go to the doctor. I didn't want to go because I said I'm going to go to my doctor. But they say you're feeling pain, so come let me check you out. So I go with them. So while I was in there, they was taking my pressure. It was very high. So they take it 2 times, it's still, so they wait a little. The police officer come to the side of the ambulance, and he gave me a card, and he said, in 3 days, call for your report. So I'm in there, they try to take my pressure again to see if it dropped. And I saw the officer come in the van, and he said, what is it happen again? So I was there because I was shook up. So I said, I was going I tell him I was on Taylor, so I make a left on Taylor, and then I supposed to make a left on Ammon. And that's when I hear pom pom on the looking back and say, oh, and he said something, okay. Okay. I said, I don't know what's happening. He probably was going too fast or something, because I was out of it. I said, probably he was going too fast or something, because I don't know how he licked me in my back like that. So the officer, he said, I'll give you my ID, and he goes. So they wasn't doing anything to my arm, because I was waiting to see if my pressure would go down. So I went out there. As you see, my sleeve was up. So I said, officer, what's the problem? He said, I'm giving you a ticket. I said, for what? I said, I'll already tell you, and you see what happened. And his word like, you probably hit him first. And it was, I think probably that's why I said what I said, like, true I'm black, or because that time it just hit me like, I'm just not getting a fair share. You're not giving me like the right, because I wouldn't just drive out in front of the vehicle like that. I would never do that. I would never do that. I stop and hail, because I remember I go around, there's a second time right there, and there was nothing coming, nothing when I make my right turn. I would never go in front of somebody like that, hurt myself and mash up my car. So I just don't understand. I know I said because I'm black and, it's prejudice and stuff like that. I know I say that, but that's what come to me at that time, because I know I was right. I know I didn't pull out in front of no one. If I did pull out in front of that gentleman, I would get it at my side. If I pull out in front of him, he would lick me right at my side part. At my rear, I didn't pull out in front of him. There was nothing coming. Ma'am, sir, there was nothing. And I know I get upset that day, because I just feel like my rights is taken from me. And that's why I get that upset that day. I didn't curse, I don't curse. You understand? That's all I could call out for, is just Jesus. It's just Jesus, because what inside I say, what have I done wrong? I was just running a little lift. I didn't, I don't know what else to say, but I know I did not turn in front of that gentleman. If I turned in front of him and he was coming, he would hit me at the side of the car, not the back. So for the officer to come and say, I was in the intersection when the gentleman hit me, that's not true. When he came, I was parking right there at Amman to make my left turn, but I couldn't make the left turn because there's other traffic coming. So you say you don't remember, and I just don't know what else to say. But I know I never fail to hail, because I always pay attention on that stop sign and the hail sign. And I know I do right when I turn right in no traffic, nothing wasn't coming. So that's all. I just ask that you all look into what you see on the video, and what was saying and what didn't do right. That's all I ask. I don't know what else to say, guys. I know I never do anything wrong. I know I do the right thing. And what get me to see the officer said when he come, I was at the intersection. And when I get upset, is because he said, I probably lick him first. I don't know why he say that. Say I probably lick the gentleman first, because if I lick the gentleman first, my whole front part of car had mashed up. So he probably just said, like, I don't have any grudge for him for that, what he said, but, he just shouldn't say that. That's why I said, not because I'm black or something, I don't know. It just come to me to just say that, the way that I feel like they wasn't doing the right thing. That's it. I just feel like they wasn't doing the right thing because I continue to say that I don't know why, but when it came, I was right there to make the left turn at Amman. And he asked me what happened, and I told him what happened. He didn't ask the other gentleman what happened. But when you're going to give him the gentleman the ticket now, that's when gentleman is going to tell him that, oh, she turned in front of me. And then he came back and take my thing and then write up the ticket from, give me a ticket. I just feel inside that it wasn't right. You know, it wasn't fair to me what happened. And then what I go through, you know, that's why I don't testify. I'm going to talk the same thing. And I don't want to go back there. So, because I talked it yesterday already. So, but what I'm saying is just, please just to see where I'm coming from. Can you see the video? And it's just never right what take place. So could just see my point of view where I'm just coming from. So thank you all. That's all I got to say. Thank you so much.
Thank you, Ms. Douglas. Anything else?
No, sir.
Okay, if you'll have a seat. All right, Ms. Tony, the floor is yours.
Ladies and gentlemen, I'd like to take this opportunity to thank you for your service. This case is not about an existential battle between good and evil. It's about a simple failure to yield ticket that was given to Miss Douglas. And I want to focus on the evidence that's relevant to the failure to yield that she was charged with. There are three pieces of evidence that are directly relevant to that. And I remind you that evidence is what witnesses on the stand said, sworn testimony and exhibits. Evidence is not argument by Ms. Douglas when she's acting in the role of her attorney. And so I urge you to focus on the witness's sworn testimony in analyzing this case. So the first piece of evidence is that Mr. Matlock was driving straight down West Poplar. He hadn't just turned onto West Poplar. He testified that he'd been driving on West Poplar for approximately 2 miles. So he wasn't pulling out in front of anyone. He had established his lane of travel on West Poplar. Officer Larrabee also testified to that, and no witness took the stand and contradicted that fact. The second important piece of evidence is that Ms. Douglas turned right onto West Poplar. She was at a stop sign on Hammond, and we talked about how Hammond is a dogleg intersection. You can't drive straight across to stay on Hammond. You have to start at the stop sign on Hammond and West Poplar, briefly turn right onto West Poplar, and then take an immediate left to continue onto Hammond. And all of the evidence in this case was that Miss Douglas turned right off of Hammond onto West Poplar just before the accident occurred. The third piece of evidence is that the damage to the vehicles occurred at an angle. Officer Larrabee testified that in analyzing an accident, he viewed it as a clock, and that this damage was at a 1 o'clock and a 7 o'clock. So it was at an angle, and Officer Larrabee testified that that was an indication that Miss Douglas had not completed her turn when Mr. Matlock struck her vehicle. So this was not a straight rear-ending situation. According to Officer Larrabee, the damage to these vehicles indicated that she was trying to make a turn. She was unable to complete that turn because Mr. Matlock struck her from the rear. I'd like to briefly talk about the credibility of the witnesses in this case. Mr. Matlock took the stand. You also saw him on the body cam, and the story that he told about this accident was the same in both instances. You saw his demeanor, and you can assess for yourselves whether you thought Mr. Matlock was a credible witness. The only other witness to take the stand was Officer Larrabee. And Officer Larrabee has been a law enforcement officer for over 20 years, investigated hundreds of accidents, and you saw everything he did that day. You saw his body cam. Now, I didn't want to show you the body cam footage. I delayed doing that because I was worried that it would embarrass Miss Douglas or upset her. And it did upset her, but in light of the allegations that she made against Officer Larrabee, I felt that it was critical for you to see everything that happened that day and to see whether those allegations were true. The judge talked to you a little bit about signing the traffic citation, and we've all gotten traffic tickets, most of us, before, and when you get a traffic ticket, you're expected to sign it. It's not an admission of guilt, as the jury charge says. It's just an acknowledgement that you have to come to court to address the traffic citation. And you saw what happened when Officer Larrabee attempted to get Miss Douglas to sign the traffic citation and everything that happened afterward. I think that the body cam footage showed that Officer Larrabee did everything he reasonably could to not arrest Miss Douglas. He did not want her to go to jail. He said that during the body cam footage. Initially, he said, I'm not going to take her to jail. I'm going to write refuse on this ticket, and I'm going to give it to her. And things escalated, and she ended up in the back of the car. And even then, he tried to instruct her to step out of the car so he could remove the handcuffs. But she would not follow his instructions, and he had no choice but to take her to jail. So I think that the body cam footage gives you a good window into what was going on with Officer Larrabee that day, and also tells you something about his credibility as well. I want to talk briefly about the law. The judge already read that to you. There are two parts of the failure to yield statute. The first one says every driver of a vehicle approaching a stop sign shall stop at a clearly marked stop line. Here, there's no allegation that Ms. Douglas did not stop. The second part of the statute says, after stopping, the driver shall yield the right-of-way to any vehicle in the intersection or approaching on another roadway so closely as to constitute an immediate hazard. Here, Ms. Douglas stopped, and she had an obligation to yield the right-of-way as she pulled out onto West Poplar. Mr. Matlock was a vehicle on that road, on another roadway, and she had an obligation to yield to him. And he clearly was an immediate hazard because when she pulled out, he struck her vehicle. This is a ticket for a failure to yield. It does not mean that Ms. Douglas is a bad person at all. It just simply means that she made a mistake. It's a traffic citation. A lot of people get them. She made a mistake and it caused an accident. And there were two people in that accident who had property damage and injury. And Ms. Douglas, based on this evidence, was the one who failed to yield and caused the accident. Based on this evidence and the law as the judge provided it, I ask you to return a verdict of guilty against Ms. Douglas for failure to yield. Thank you.
All right, members of the jury, what I'm going to do is, as I told you, I'm going to need to make a quick correction. I've actually already finished that, but I need to print it and show it to them before it goes out with you. So I'm going to read to you your last instructions, and you're going to head back there. So your last instructions for me are, In a moment, you're going to retire to the jury room, but do not begin your deliberations until A, you've turned off all of your cell phones and you've handed them over to Miss Margaret, who will protect them with her life while you're having your deliberations. We have learned the hard way as judges that the phones are simply too tempting during such an important decide because we all reach for them all the time. So turn them off. We will protect them, and you'll get them back once you render your verdict. You will also receive the verdict form, which is right here, of course, with the attached accusation. You'll receive the evidence in this case. Now, you'll get the photograph. Obviously, the video is not in a format you can use back there, but if you decide you want to watch the video, you let us know, and we have a procedure for that. And then lastly, you'll receive the corrected written copy of this charge. With that said, if you all will step back in the back, wait just a minute, let the bailiffs bring the stuff back, and as soon as you have those items checked off, you may begin your deliberations. All right, jury's out. Any objections to my charges?
No, Your Honor.
All right, any objections to my charges, Ms. Douglas?
No, just can I say one thing?
So quickly, I got to move on to my next topics.
Yeah, what's the name again? I don't know your name.
Ms. Tony?
Oh, Miss Tony said, I was on Ammon when I made that turn. I was on Ammon.
Miss Douglas, closing argument is not evidence. And so when misstatements are made in closing argument, they're just what they are.
Yeah, but she was wrong, yeah.
Well, you think she was wrong. I don't know if she was wrong or not. She could say that flying saucers came down from the moon and that part of it. In closing arguments, you can almost get away with making that statement. Closing arguments are about being colorful. And so I'm just simply saying your opinion of her closing is irrelevant unless she is intentionally misleading the jury into the wrong way. So your objection about it is A, untimely, and B, overruled. Okay, next topic. Anything else?
No, it's just, she just
Okay,
said wrong.
I get it.
That's
but-
okay, yeah.
But I'm not the one making the decision, the jury is, and they're gonna make it based on the evidence. I need to go grab the updated version off the printer. Miss Douglas, you need to take a look at that picture that's gonna go out with the jury. And take a look at the verdict form. Miss Tony, I'll let you start with that. Let me grab the verdict form and then we'll get it out to the jury. So, yeah, y'all just take a look at everything. I'll be right out. All right, let's just put on record. So it's 10:43. Our phenomenal bailiffs have taken out the corrected jury charge, the verdict form with the attached accusation, the photograph, and they've collected, and I see a nice stack of phones there. So I believe everything is in. Any objections or anything else that the state needs to put on the record before we adjourn while the jury deliberates?
No, Your Honor.
Okay. Ms. Douglas, is there anything else we need to put on the record um, before we go into recess while the jury deliberates?
No, sir.
Okay. All right. Well, then we are in recess until the jury has a question or a verdict. Everybody's feel free to move about, but just stay within earshot of that door right there. before we jump in. Ms. Douglas, so what's about to happen next is the jury is going to come out. I'm going to identify the foreperson, and then I'm going to ask that foreperson if they've reached a verdict. If they say yes, I'll ask them if it was unanimous. And if they say yes, I'll ask them if they filled it out in pen. If they say yes, I'll have them pass it over to the bailiff. I'll look at it. I'll make sure it's in proper form. If I think it's in proper form, I will read it out loud. It's no secret, and it's okay, Miss Douglas, that you have deep and strong emotions, and that is okay. But I need you to know that I will not tolerate deep and strong emotions at this moment being displayed. All emotions are appropriate. Not all actions are appropriate. Do you understand the difference between those?
Yes, sir.
Okay, because obviously we've had some very emotional moments in this trial. We watched the video where things were very emotional. But I need you to know that any display in front of this jury, as they render their verdict, either joy or upset, will have zero tolerance from me in the same way I wouldn't tolerate it from anyone else in this courtroom. Does that make very clear sense to you?
Yes, sir.
Okay. And whatever that verdict is, we're all going to sit here quietly. We're going to process it. I'm going to release the jury, and then we'll deal with, if it's not guilty, I'll walk you through what happens next. If it's a guilty, then we'll talk about what happens next after I've let the jury go. Okay? All right. Ms. Tony, you ready?
Yes, Your Honor.
All right. You ready, Ms. Douglas? All right. If the jury is ready, they may come on out. Okay. Everybody may be seated. All right. So I assume you are the foreperson. All right. So let's just do a couple things. If you'll stand up for me and state your full name.
Yes, sir. Dane Cole Slaughter.
All right. And Mr. Slaughter, you have been elected as foreperson. Am I correct in understanding that I just have a couple of very specific questions, and then I'll have you hand that to Clint. Have you reached a verdict?
Yes, sir, we have.
Is it unanimous?
Yes, sir, it is.
As the foreperson, have you correctly written down the verdict in pen on the verdict form?
Yes, sir.
Okay, if you will pass it over to Clint, I will take a look at it. If it is in proper form, I will read it. You're welcome to sit back down. Okay, the verdict is in proper form. It says, "We, the jury, find the defendant guilty," dated April 23rd, 2024, signed and dated. Mr. Clint, will you show this to each of them so that they can get a look at it before I cut the jury loose? Any objection to the form of the verdict?
No, Your Honor.
Ms. Douglas, is there anything else with regard to the jury that I need to address before I release them and we discuss the next phase of this case?
No, that's okay.
Okay. All right, members of the jury, I just want to say, I said thank you first, and I want to say thank you last. You all have lives to live, you have things to do, you have family members and coworkers and other people that rely on you all to be certain places and do certain things. You gave those up so that you could come here and do this for $25 a day. I just can't tell you thank you enough for that. You jurors in Georgia are not paid near enough the value of the service they provide. So I just want to make certain that on behalf of the entire state court team, Clint, you can give back their phones now. So Clint's going to pass back out your phones to you so that y'all have them. I assume y'all know which ones are yours.
I don't know. Stay away from
Okay, that way the record's clear that everybody has their phone back. So I've been, I told you yesterday, and I told you each time we took a break that you couldn't talk about the case or anything else. That oath is over because you've rendered your verdict and the case is finished. So if you want to talk about the case to every single person you meet, you can do that. If you want to talk about the case with no one, you can do that. Sometimes the solicitor's office, or often the solicitor's office, will want to speak with you about your thoughts and impression of their case. They may reach out to you. If you want to stick around after court, when I release you, they're going to send you out this way and down around the hallway. If instead of turning left and going to the elevator, you want to take a right and come back into the courtroom and sit out in the gallery while we finish up the case, you're welcome to do that now. And so I just want you to know that whether you stay or go from this point forward is your decision. Whether you talk about it or not is your decision. I believe that what will happen is this is our last case. So as of today, y'all are officially finished and you'll mail it. Okay, so they will mail, they'll mail the checks in the mail. So the clerk's office will mail you the check. So as long as the address that the clerk's office has with you is correct, then you're good to go. Your juror badges. So one of the things that we did was we ordered a big box of those so that we can let you all each have one as a memento to say thank you. It's not the best parting gift you've ever gotten, but I just want to give you just a little something. I would only ask you not to wear it back into the courthouse tomorrow or anywhere after, as your service has concluded, and that would be confusing. But with that said, as far as your notes go, just leave your notepads, just the notepads, face down on the table. The bailiffs will destroy the notes. No one will see them, but the bag, the rest of the bag and the rest of that stuff is yours to keep. Does anybody need to work, something from work, something to show that you were there? Okay. Does anybody need anything else from me? Any questions, no matter what? I'm happy to answer them. Okay. So again, keep your juror badges, keep everything in your bag except your notepad. Put the notepad face down on the desk, grab your items, and you're going to head out that door and take a right. If you want to come back in and watch the end of the rest of the matter, you can come back in on there and sit out in the gallery. If you want to take the elevator and go. And again, if anybody wants to speak with you, you can talk to them or not. Okay? Thank you. Thank you. Thank you. All right. You want me to step out? All right. We're at ease till they gather their stuff and move out, and then we'll figure it out. Just said they don't want to come back in, so that means we're all clear and we can finish this up. Okay. Ms. Douglas, let's talk a little bit of housekeeping. So, Ms. Douglas, just to reiterate how we got to this point, we're here and we've just finished your jury trial, and the jury today, April 25th, 2024, found you guilty of failure to yield at an intersection. I, I just want, I just want to stress to you, because I keep thinking this is getting lost in the noise, that this is not a murder case. This is a traffic violation case. And most of us in this room at some point have been involved in a motor vehicle collision. I know I did. When I was in college, I pulled out in front of somebody when I was turning right, and that person hit me from behind, and it was my fault. And I just want you to know that, like, I'm sitting up here as the judge over your case, and I had the same thing happen to me when I was in college. So I just need you to understand that no one in this room is accusing you of being evil or bad or wrong. Strict liability offenses like this are just called mistakes, and the jury has ruled that you've made a mistake. And I just need the record to reflect that this is not the case. This case is not what you have said it is in those terms. But the jury has found you guilty, and it is now my responsibility to sentence you. And my inclination is to simply sentence you according to the fine on the case, which would, I believe, be $300. Is it 300? Let me look it up. I think it's written on the citation, but
It is, Your
I
Honor.
can't find where my copy is.
I have a copy.
Oh, what's it say at the top?
300.
Okay.
There is this amount here seems to have been written by the city of Griffin
Oh,
before it was
okay.
found over, but
Because it was an accident.
yeah, this was ours.
So, Ms. Douglas, I do not want to place you on probation. Frankly, I have no inclination to put you in the jail, but I do need to fine you. Do you have the $300 to pay?
No, sir.
Okay. So that puts me in a bit of an awkward spot. I can either, so that means I have to revisit the question of, I can put you on probation, which I'm frankly not, I'm just going to say this as gently but as directly as I can. After watching you in the video where a minor offense was turned into a major problem, I don't know that you're a candidate for probation. I don't know that I can trust that you will go work with my sentence enforcement department and do what you're supposed to do and act the way you're supposed to act if they say something to you that you don't like. And I'm just saying, do you have any fine amount today that you are able to pay to satisfy this and go? Because I have a solution for this that you are not going to like. So I'm going to reiterate my question. I would like very much to let you pay a fine and go home and be done. But after this trial, I don't want to put you on probation because I don't think you'll do a good job with it. Do you have any amount at all? And I have never asked a defendant that question at the end of a jury trial. I need to make certain that is very clear. I have never once said to a defendant, do you have less than my sentence? Because I would like to discuss that with you.
So I just pay my mortgage, so I don't know how much. I don't have 300. I don't have 300 in my account. I just pay my mortgage.
Okay, well,
So-
that was not the answer to my question, though. We've done this a lot, where I've asked you a question and then you've said something kind of random and somewhat related to my question. So let's do this again. I want you to listen to the words coming out of my mouth, and I want you to answer the question that I've asked you. I did not ask you about your mortgage. I asked you if you had any fine amount at all that would let me not have to explore these other options that I don't want to explore. I'm trying to let you pay something and go home, and I cannot believe I'm having this discussion where I am considering lowering your fine. So can you meet me anywhere in here where I can put a fine on the table that you can pay and go, or do I need to explore these other options?
I don't know if I have $80 in my account.
Okay. You don't even have $80 in your account?
No, I said I don't know if I have. Probably
Okay.
have 80.
You were aware that you were potentially going to be found guilty of these charges, correct?
No, sir, because I know I didn't turn in front, but
Yeah, I know that, but I'm saying when you came to this jury trial, there were two possible outcomes. Guilty, at which point there would be a sentence, and not guilty, at which point you would get to go home. You would agree with me that you had to at least consider the possibility that the jury found you guilty. Did you ever consider that possibility at all?
no, because I know that I wasn't wrong.
Okay. You have 30 days from today to appeal this decision. I'm going to go into reset. I mean, I don't know, Miss Tony. I know my solution. She's not a candidate for probation. She's not a candidate for probation. I just watched an hour of her screaming and yelling and refusing to sign a citation. I cannot subject my sentence enforcement team to her.
Sir,
Let's go into recess while I think about this. We're in recess.
sir,
10
I'm
minutes.
not a bad person. I'm just,
I didn't say
know
you're a bad
that,
person, but we're in recess.
I
I'm
know
gonna take a
that-
10-minute.
I wasn't wrong.
Stop.
okay.
I said stop. We're taking a 10-minute recess because
Okay.
what I'm about to do in your case is what you don't want me to do. Okay? You have backed me into a corner here, and I am trying to find a solution for you.
Can I
And
come-
No, I'm about to step off this bench because that's what you need me to do right
No,
now.
I wanna call and
You
see-
need me to step off this bench.
Okay.
All right, let's start with the first thing. Ms. Douglas, I'm aware that as the judge of this courtroom, I have all the power, you do not. I owe you an apology. It is never acceptable for me to lose my temper in the way that I just did. I just wanted to make certain that that was the first thing I said when I came out here. That no matter how frustrated I get, it is my responsibility and my obligation to you and everyone in this courtroom to keep my cool and to run this courtroom efficiently and well and protect the rights. And I have no excuse for the fact that I lost my temper with you, and I am genuinely sorry. And I wanted to make sure you heard me say that I am genuinely sorry. Instead of arguing with you for leaving the bench, I should have just left the bench. I will say, though, to back up just a hair, my frustration, though, I do need to acknowledge was reasonable. My response to that frustration was you can turn your phone off. Go ahead. All right, you got the ringer off now?
Yeah.
Okay. My frustration was reasonable. My response was not. And so I've been on the bench long enough to know what I should have done in that situation. I didn't do it. I went back into my office. I calmed down a little bit. And I came up after talking with my team with a solution that I think balances the interests here. And so I'm going to start over here and I'm going to sentence you the way I should have when we first started this process. Ms. Tony, do you have anything else that you wish to add for sentencing?
No, Your Honor.
Ms. Douglas, the sentence of the court is, let's see, the incident date is May 11th of 22. Ms. Douglas, the sentence of the court is as follows. As to failure to yield with an accident, the jury has found you guilty. The sentence of this court is 12 months of probation, a $300 fine. Of that 12 months of probation, I'm ordering you to serve 30 days in the Spalding County Jail. Follow me to the end of what I'm about to say and understand what your options are here. This is consecutive to any current sentence. You're going to show a valid license to the Sentence Enforcement Department. You're not consuming illegal drugs, alcohol, or hemp products, and you'll be tested for those. You're to pay $50 per month as a supervision fee, and you're to pay a one-time $25 intake fee. This case may close the moment you've satisfied your obligations to the court. You are on zero tolerance for the duration of your probation. And what that means to you is there's no walk-in hearings for you. If you don't do exactly what you're supposed to do and exactly the way you're supposed to do it, sentence enforcement is going to take a warrant first, and they're going to figure it out second. Because I just watched 50 minutes of officers trying to release you, and they can't even get you to get out of the car so they can take the handcuffs off. And they can't even get you to sign this document so that they can release you and let you go home. And you chose in that moment to go to the jail rather than interacting with them in a civilized and appropriate way. You have every right to challenge it. You just did. And that's what you should have done. So your 30 days in the Spalding County Jail starts Friday, May 31st, 2024 at 6 p.m. sharp. However, your case is terminated upon completion. And if you successfully close your case before Friday, May 31st, 2024 at 6 p.m. sharp, you will not serve that jail time. But if you don't do what you're supposed to do, then you will turn yourself in and you will serve 30 days in the Spalding County Jail. Because I am not going to subject the sentence enforcement team to 12 months of what I saw on that video. So in 60 plus days, your case is going to be over one way or the other. You're either going to do what you're supposed to do and close your case before May 31st, or you're not going to do what you're supposed to do. You're going to turn yourself into the jail on May 31st. And once you've started your 30 days, they're going to terminate your case and you're going to finish out your 30 days and your case is going to be closed. Do you understand that you control the pathway of what happens next? Do you understand that, yes or no?
Yes, sir.
You have 30 days from today's date if you wish to appeal this decision. You have 6 months from today if you wish to use your habeas rights. I need you to understand what zero tolerance means, because a deputy is going to be standing with you while you're back there meeting with sentence enforcement. Because again, I just watched almost an hour-long video of deputies trying to get you to sign a document agreeing to a court date. And I saw what happened there. And so here's the deal. If you don't sign the documents that are placed in front of you in a polite and civilized and appropriate and timely way, they're going to come in and tell me, I'm going to immediately sign a warrant and you're going to immediately be taken into custody. Because I'm going to come back to my original point. I do not want to subject the Spalding County Sentence Enforcement Team to what I saw on that video. Do you understand what I have just said to you?
Yes, sir.
Do you have any questions that I can answer for you?
Yeah. I was just telling you a while ago that I didn't have no money in my account because I got to use the bank to pay off of my mortgage. So I was telling you if I could make a phone call to get some money to pay. That's what I was asking you, but you went away.
Did you use the time that I was off the bench to make that phone call?
Yeah.
And?
Yeah, that's what I was asking you, but you get upset. If I could call somebody.
Okay. And what did they say when you called them when I was off the bench?
Yeah, to ask you if I could go to the Western Union.
Okay, that's a no. You're not leaving here to go get anything. You can just pay it through them. So, okay, we're done. You can go with Ms. Temples. One of the deputies will go with Ms. Temples. And I can go ahead and tell you right now, you better be on your best behavior, or this is going to be a very short probation for you. Okay?
So if I pay the $300, no.
You have to pay it in a few other odds and ends, but as soon as you pay it and do those few other odds and ends, because it's going to end up being you know what, I'm not going to give you that number, I'm going to mess it up. It's going to be somewhere closer to 400 with everything added in. But as soon as you get that number paid and plus a couple of odds and ends, like show them your valid license, they'll close it. I don't want to revoke your probation, but you need to know that what it would take for them to get me to sign a warrant for your arrest is about this much. And for the record, I'm holding my thumb and finger about an inch apart. Because again, after watching an hour of that video of these officers trying to get you to just sign a ticket and how hard they worked not to take you to jail. And I tell you, the part that hurt my soul was when your fellow parishioner, your church family lady, who worked at the jail came out and was trying to talk to you and get you to calm down, and it still didn't work. I just am not going to put my team through that over here. Okay?
So can I say something? She's
You
not
may.
she's not my church sister. I don't know. She just